You're live.
All right, good morning. We are in Senate Judiciary. It is February 18th. We're going back to S-193 after our conversation yesterday to see what markup and what questions we may develop for our witnesses who are coming in on Thursday. And we highlighted a number of decision points raised yesterday. We want to give the committee a day to think on things and see if we're able to get to any decision points, and also just to continue the conversation that we had from yesterday. And we have Ledge Counsel here with us as well. Eric, did you have anything that you wanted to start off with?
No, I think, as you said, Senator Hersheen, that the committee yesterday identified about 6 or 7 decision points to think about, and there wasn't any additional language to add at this point. I mean, there were a couple of technical pieces that during the walkthrough yesterday, the committee noted it would be on the next draft, but for the most part, it was really just a policy discussion that the committee was going to have next about, in addition to hearing witnesses. I mean, you got a lot of that lined up for later in the week as well, but at this point, I think it was more of a committee discussion about policy preferences.
So I guess we can just start with section 1. Committee, are there any initial thoughts as to changes that we may want to add? I know that one of the changes was that we wanted that the services shall include appropriate combination of medication and so on, but anything else in this section at the moment?
Not for me.
Eric, did you give any thought to the hold without bail hearing?
I haven't had time to do that, no,
Yeah.
sorry.
Yeah. So, I mean, would it make sense to add a placeholder then, just stating that prior to somebody being released, well, actually, would it make sense to have a hold without bail hearing prior to their release, but it wouldn't make sense to have it if the charges were dismissed?
I wonder if we might, or I could reach out to someone in the judiciary or on either side of the prosecution and defense, because I'm curious about, there is sort of this parallel proceeding that does exist with respect to, if someone is found incompetent or not competent to stand trial, I should say, and under existing law, and then the court holds a hearing to determine whether they're dangerous to self or others as a result of a mental illness, and they can be committed to that whole civil commitment process. So it occurs to me, maybe the same question would have come up. It's sort of a similar question, right? What if there's a hold without bail order in that situation? Or would they defer the consideration of the hold without bail issue until after competency is retained? So I don't know if that might be worth looking into to see if they already have sort of a sequence that they use for that.
For the civil commitment?
Yeah, right. It's sort of a parallel idea that has existed for quite some time. So just occurred to me that perhaps the Judge Zone or someone else in the judiciary might already be able to say, well, this is how we do it, and that.
We have him up. We don't have, we did already hear from Judge Zone, but I think that was a much earlier version of the bill.
Yeah, for sure.
So I think if that's the only question we have for him at the moment, I think I'll just send him an email and CC the committee and you as well.
Sure.
See what his recommendation might be. And are there any other recommendations or suggested changes for section 1. Anybody else?
No.
Alright, so section 2, that is the dismissal piece. I think the only question there was, is it going to be with or without prejudice? And any changes or recommendations for the language in section 2?
As I said yesterday, I'm fine using with prejudice because the court can still find that a dismissal would be contrary to the interest of justice. So, and since they've already waited out the maximum sentence, it seems to me like they shouldn't come up for those charges again.
Yeah, I think there could be two scenarios, I suppose, where, let's say one of these cases is pending and hasn't yet been dismissed, and then there's another life offense charge, and the timeline is hit for that misdemeanor offense, then the judge could say it's in the interest of justice to keep the case. Whereas if it's dismissed with prejudice, and then later on, another offense that is connected to that course of conduct happens, another life offense, but it's already been dismissed with prejudice, then it can't come back. So there's two pathways that it could go. So I guess I don't know if indifferent is the right word, but ambivalent, I guess, as to whether it's with prejudice or without prejudice at the moment. Yeah.
I feel like if you look at it from a certain perspective, you would never want to dismiss a case with prejudice because there could always be some circumstance where you want those charges hanging around. I just think there are other, and in my feeling, stronger reasons to dismiss them with prejudice because basically the person has already served that sentence. So I can't see the utility in having it be without prejudice.
Ordinarily, you raise your hand? Okay. Ordinarily, I mean, it's, when these cases are inactive, it's usually somebody who, if they're not being detained, it's, somebody who is on conditions of release for a number of years, which is not nearly the same as being on probation or obviously being detained or sentenced. So, yeah.
And to clarify, so that's how I would vote, but if the committee votes to have it be without prejudice, it's not going to mean I don't vote for it.
Then vote.
I am inclined to agree with Senator Baruch that my preference is with prejudice, especially knowing that the evidence of that behavior could still be used in a later case to sort of prove that pattern of behavior. And presumably, if someone is not, well, I guess not, because it's not a life offense. Yeah, I think I agree with Senator Baruch. That's not my major sticking point in this bill, but.
Senator Norris?
I said yesterday, I will go against the grain again as usual. And I like it without prejudice. If in fact the courts can still use the information at a later date and time. If you dismiss it with prejudice, then my concern is, can they go back and file charges on that particular thing? From something that was dismissed with prejudice moving forward.
Yeah. I mean, historically, as far as I'm aware, when a case gets dismissed with prejudice, it's usually due to a defect in the case or insufficient evidence or something along those lines. But yeah, I guess ambivalent at the moment. So maybe
Looks like we need Senator Matos here.
Yeah, this particular piece isn't the hill that I want to die on for this, but I guess I just need to think on it a bit more as to what I think makes the most sense, in my opinion, on this one, but at the moment, kind of on the fence about it. So I guess we can just leave it as it is for now. Unanswered decision point.
Okay.
So that brings us to section 3. Any proposed changes to this piece?
I'm going to toss up the main, sort of the main decision points here.
Yes,
Would that be
that would
helpful?
be good.
I think throughout this section, it's at least several times, the same decision point comes up. The first time, if you want to look at it as an example, would be page 5, line 60. And it has to do with who bears the burden and what the standard of proof will be. I think that's sort of a key question about the not guilty by reason of insanity avenue, which is, that track is what's being talked about in this section of the bill. And remember, the way the bill is set up is that what's referred to as the insanity acquittee, that's what the courts refer to as someone who's been found not guilty by reason of insanity, bears the burden of establishing by clear and convincing evidence that they're no longer suffering from a mental disease or defects that upon their release would create a substantial risk of bodily harm to another person. And that's, as I had mentioned yesterday, has been the subject of a lot of court cases throughout the country, a lot of different courts. I think the Supreme Court has certainly said that it's okay, very permissible to have this person in that, as a result of an NGRI, not guilty by reason of insanity verdict, go directly to commitment without an intervening proceeding right away or finding right away. They have to go right to commitment. That's acceptable under due process standards. I think by implication, at least, so they didn't address it specifically, by the cases they were looking at also had the burden shifted, so it was on the person committed to have to establish that they were not dangerous and were not suffering from mental illness. Didn't decide the standard of proof. In those cases, it was a preponderance, it's a lower standard than clear and convincing. So I think that the one bit of background on that, as I mentioned yesterday also, whatever you decide, because this is such a new issue in Vermont doesn't have a statute like this. So assuming something passes, whatever choice you make here, I think you should expect that, because under the Vermont State Constitution, a statute of this type has never been analyzed before, because we don't have one. We're one of the few, if only, states that doesn't. So it just shouldn't be a surprise. And of course, it will be litigated.
Yeah.
You know, whatever direction you choose to go here. So still, whatever policy you think makes the most sense, I think you are free. In other words, no constitutional reason you can't choose to do that the person has the burden of proof and whatever standard you think is most appropriate. Just Vermont, just one last little piece, just so you know too. I think, again, I didn't see all 49 other states. I didn't see a collection of them anywhere. It appeared to me that the majority of states do shift the burden to the defendant, right? The person who's been committed. So in other words, it requires them to do the establishing of their state of mind. And it appeared to me that the majority of states use a preponderance standard, not clear and convincing. But again, both exist, and you can choose whatever you think is.
So the majority use a preponderance?
Again, it appeared to me, yeah. I was sort of taking, what would you call it, a statistical sample, I guess, since I had seen all 49. I looked at 7 or 8, and of those, the only one that's used clear and convincing was the federal one, and all the state ones. Now, it could be that, of course, I happen to have randomly looked at the first 6 or 7 states I looked at were all preponderance. If I looked at the other 42, maybe they were all clear and convincing. That's possible, you never know. Seems unlikely.
And
But-
one last, oh, go ahead.
No, that was
I was just gonna say, maybe this is a quick clarifying question. Do you know if at these hearings,
it.
representation would be guaranteed for the defendant? Because it's not criminal, they're not technically sentenced to jail, they're likely going to be indigent.
That's a good question, because the language certainly does not say anything explicitly about that.
Yeah, I would wanna add something along those lines.
Yeah, yep. I have seen that in other state statutes, now that you
Yeah.
mention it.
Yeah, because I just wanna make sure that's in there for this, and then we can come back around to whether we should have a preponderance of clear and convincing. Senator Rokuski.
Thank you for asking that question. That was one of mine. Do you have a sense of if one is more defensible than the, like, we know this is gonna get challenged, and I feel like we've been dealing with a lot of things we know are gonna get challenged, and the way we've tried to thread that needle is really looking at what is the most defensible. Do you have a sense in this instance, you know, logically, again, I know the law often doesn't necessarily work logically, but logically for me, going the way that most other states go feels more defensible. But I don't know if you have a sense on that.
I think it's hard to predict. It really is. I think that the shifting the burden generally seems to have been an accepted practice so far. But again, the Vermont Supreme Court, when analyzing claims under the Vermont Constitution, is sometimes more protective. So it's hard to predict.
Okay.
Sorry.
I also wonder if, and this is not really a question for you so much as the room, if CSG's Justice Project might have just some information about, like a kind of clearinghouse. No, the Council on State Governments.
Oh, council.
If they might have, I don't know, a chart of like how other states do this. I know that they've done that. They've had those before available for other policies. You know, this is what each state does. Maybe that is a statement for you as well, Eric, but I don't know if it would be helpful to have them sort of give us the broader picture.
Yeah, that could be helpful.
I could also ask, let's see if I can check, see if they happen to have, you know, done some work in this area.
Yeah.
Did you use the jurisdictional survey feature on Westlaw? Was that what you had used for, to figure out? Michelle had showed it to me last year. It was a useful tool, but.
No, interesting. No, I was just using the key sites for, you know, once I found a couple of cases that were dealing with this issue, I was just looking and jeopardizing them. But that feature is interesting as far as jurisdictional in terms of telling you what comes up with a list of jurisdictional approaches.
Yeah, basically, if you we used it last year for what was it? I think extradition, and it compared to all the other states. Their extradition rules, the timelines compared to what we were considering. So that might be, and I can look at that as well.
I'm interested in it, so I'll follow up too.
Yeah.
I didn't try that.
Yeah, it was useful.
Yeah, I'll ask Michelle.
Senator Ruth.
So my feeling about this is, if we shift the burden, we're asking that person or their representative to prove a negative, that they're no longer suffering from this disease by clear and convincing evidence. It seems to me that's a very, very high bar. So it doesn't strike me as unreasonable that most states that you looked at went to preponderance. So my preference there, and again, not a do or die for me, but I would, if we're gonna shift the burden, I would rather have it be preponderance than convincing.
Yeah, no, that makes sense. I think, I mean, just to clarify, it's not necessarily proving that the person no longer has a mental health issue, but rather proving that as a result of the mental health issue, they're no longer going to be a substantial risk
Right.
of bodily injury to another person.
But same argument. In other words, if somebody was suffering from a mental illness that the system thought was likely to lead to bodily injury, and then the person gets into this hearing, what would be clear and convincing evidence that that's no longer true? I mean, you could say, well, he behaved or she behaved during this interval,
Yeah.
but so it seems like the best you could hope for is that in the hearing, it might seem more likely that they're not gonna hurt someone rather than clear and convincing. Because it's not like a broken bone or something where you could say it's healed. You're always kind of, there's a certain amount of guesswork involved, I guess.
Yeah. I hear what you're saying. I think, I mean, this is speculative because we don't have these hearings at the moment, but, you know, generally what I would anticipate is their counsel representing the, whatever therapy they may have gone through, whether they have a support structure outside, whether their behavior has changed since being detained, if they're on new medication that has changed their behavior as well. So I think there would be, and they would probably likely call, you know, whoever has been treating this person as a witness to show the behavior from before is no longer happening as a result of the recovery and rehabilitation that the person's been going through. So I think that's how a hearing would go. But, you know, I think to your point as to it being a preponderance, I would tend to agree. I think in Vermont, our Constitution tends to provide a higher bar when it comes to fundamental rights, and I think that you know, it's permissible to shift that burden. But I was looking again through U.S. versus Weed, which talked about the heightened burden of proof increasing the likelihood of an erroneous deprivation of liberty, and in considering that, I think it would make more sense to shift to a preponderance rather than clear and convincing.
I could certainly support that.
Senator Norris, do you have any thoughts?
I do. Basically, in my mind, this is how I look at this. This is the defense that raises insane defense. And now we're saying, and the point that the chair brought up was a valid point. Okay, representation, if in fact this ever comes to fruition, obviously. But I just don't feel comfortable knowing that someone's being evaluated, they prove beyond the preponderance, which is, we know, is the very minimal scales, that they're not going to go out and hurt themselves or somebody else here, especially if it's any one of our family members or whatever else. So I'm not saying beyond a reasonable doubt, but I still cling on to that clear and convincing standard as far as I want a little bit more than just preponderance of evidence. They're not going to hurt somebody, is what I'm saying here. That seems like it's, I don't know, we look at these things all the time as defense-wise and whatever else, and a potential victim or past victims or whatever else. So I can't go along with the preponderance of evidence, which I brought the point up the other day, is in a criminal court. Maybe they do, but I don't see that used that often, preponderance of an evidence. In civil proceedings, you do.
Right.
And this is what we're talking about, is criminal proceedings here. Or the lack thereof, I might add, but I'm not comfortable with putting somebody out on the street on a preponderance that they may not hurt somebody. That's the way I'm looking at this. I think we have not only a duty to the individual who's being held, we have a duty to the public at large also. That doesn't rise to the bar that I'd like to see it.
Senator Rose?
If someone has been deemed not guilty by reason of insanity, they're no longer in the criminal court system, right? This is all civil court stuff. Because they have been found that they've been found not guilty.
It's an interesting, I think as the Attorney General's witness was testifying last week, these are unusual proceedings that blend elements of both. For example, these proceedings are in the criminal division. And yet, because they are commitment, they are what historically are more civil in nature. So it's not a strictly criminal proceeding anymore, but it is in the criminal division.
But
So-
isn't that a hanging question as to whether it should be in the criminal division or in the civil division that deals with this type of hold with that, like,
Certainly, that's a policy decision for you guys.
yeah. This was, I think, one of the questions I raised yesterday, is if it's the civil division that generally deals with involuntary commitment, shouldn't they sort of deal with all of them regardless of how they get there? Rather, than standing up a whole new system for, I think they said, what, maybe 4 to 6 people?
Yeah, I think that's a discussion for this committee to have, certainly. And you could even, I don't know if this was also something I'd been alluded to yesterday, but, it's also theoretically possible, because I remember it came up in the context of the involuntary medication issue.
Right.
In theory, like that issue could be confined to the family division, even if the rest of it remained in the criminal. Again, sort of, given the family division's experience with involuntary medication proceedings. But anyway, certainly options for this committee to think about.
We're in uncharted waters.
Correct. I would say that's,
So it doesn't matter which one we're in uncharted waters, this is going to be challenged.
yes,
Okay, so I don't care if it's criminal, civil, whatever else, I'll just talk about the use of preponderance of evidence.
right.
I still have difficulty in wrapping my beliefs around that we just simply release somebody on a preponderance that they may not hurt somebody. That's where I'm coming from.
Right.
I don't want to be that guy.
I'm wondering if we were to switch to a preponderance, if we were to also add a list of factors that have to be proven or taken into consideration beyond just whether or not the person would be a substantial, would pose a substantial risk. And so I'm thinking about, requiring that the court shall consider.
Don't we already have that above? I mean, not that we couldn't
That's the
add
forensic
elements to it.
assessment, so. And then D is the final piece that goes into the hearing, right?
Yeah, you're right, that's the forensic risk assessment.
Expand out D to include elements.
Yeah, that's what I'm thinking when I'm looking at, starting on line 15, where it talks about the hearing. Do we add a list of several factors that the court shall consider to make this a bit more specific? If we're going to have a lower standard of proof for evidence.
There's another piece here that we haven't talked about. So it's, as it stands on paper, burden is shifted, clear and convincing that it would create a substantial risk of bodily injury. So if it says preponderance and we leave substantial risk, it seems to me we're covering ourselves there. So we're saying, it's more likely that it won't create a substantial risk of bodily injury. So no matter which standard we use, substantial risk is another judgment factor there. And all of this is going to be decided by the court. So I feel like what it boils down to is a judge reviewing the person's risk assessment and saying, I don't think this person's going to hurt anybody. So I guess that boils down to me feeling like preponderance wouldn't be turning people loose that the court believes are going to hurt. But
I think the counter to that, though, is if it's a substantial risk,
yeah,
then it's, is the person going to go and shoot somebody, or is the person going to go get in a bar fight? And, because getting in a fist fight is, I would say that's a risk of injury, but obviously shooting or stabbing somebody with substantial risk? Or is it taking more into consideration the likelihood,
Yeah,
substantial risk? Yeah, I'm not sure.
I think it's the likelihood, the way I.
Yeah.
What I'm trying to get my head around too, that's, it's a logical, I'm not able to quite do it. Think about what Senator Norris was saying, and without just trying to articulate, whether you had the word substantial or not, if you were thinking about that, and let's say your goal was to make it, to use the preponderance standard, but to make it more challenging for the person, committed person, to meet that standard, because you're concerned about them being released on too low a standard, right? Does that mean you include the word substantial or not? See, I'm trying to figure out how.
I think it would be more difficult to prove if you remove the word
That's what I'm saying.
substantial, because when I think of substantial risk, I'm thinking it's very likely.
Yep.
Whereas risk of injury is moderately likely. So
Right.
I don't know if removing the word substantial, but and adding preponderance
yeah,
kind of gets to the middle road of Senator Norris's concerns, but also the concerns of having this not be clear and convincing.
I know, it's like a logic problem, I can't.
Senator Norris.
Yeah, I've got a question here, and it's probably covered somewhere in here, I'm sure it is, so if we look at pointed out to me. On the lines 13 and 14, where it says a substantial risk of bodily injury to another person, could it possibly also report to themselves? Or does that cover here someplace else? I mean, we're concerned about their well-being too, obviously.
yeah.
The way it's drafted now, and it doesn't include themselves, but you could if you wanted, certainly.
I'll just inquire what you,
Yeah.
what do you think about that?
Yeah, sure.
Good point. I wouldn't be opposed to adding substantial risk to themselves or risk to themselves, depending on how we go. But Senator Bruce and Senator Wilson.
Just a quick thing. So I think what we're talking about is if you let the person out under any circumstance, there's a risk, because you can never be 100% certain. So even if you were 99% certain, there would still be a risk. That seems to me why substantial is there, because there's always going to be some level of risk. And if you reduce it to just risk rather than substantial possibility, then I think the person's never getting out. So I guess what I'm trying to avoid in the statute is a situation where there are a number of hearings, but basically they're for show. This person's never getting out. I think leaving substantial risk makes sense, and we should argue out what the evidentiary standard is with substantial risk in place, if that makes sense.
So are you referring to adding a list of factors that have to be taken into consideration or something?
No,
whether
so
it's preponderance or clear and convincing?
yeah. So I might be arguing against myself here, because maybe if you have substantial risk, people will want clear and convincing. But I think if you take away the modifier on risk, then it's just, is there any risk at all involved with letting this person out? And I think the answer is always going to be yes, there's some risk, because they're there for a criminal action. So substantial risk seems to me just recognizing the obvious, which is that there's going to be some level of risk if you let them out. Of course, making a judgment call about it.
Senator Wilson.
So I agree with Senator Burr. I mean, there's some level of risk that any one of us could harm someone else, even if we haven't done that before. So I mean, that's just human. My question is around the constitutionality of holding someone in a facility like this, not because they're a risk to other people, but because they're a risk to themselves. Like, I know we can do short-term sort of civil commitment for stuff like that, but can we hold someone in a forensic facility that is meant to deal with not guilty by reason of insanity because we're worried they're a risk to themselves?
That's an interesting question. I haven't looked at that question specifically. I went and sort of looking at all these cases. I wasn't focused on that.
Right.
That angle. But it is a fair point that as opposed to the civil commitment context, when you're talking about an involuntary commitment of somebody because they might be dangerous to themselves or to other people as a result of a mental illness, this one being a forensic approach, which is different, criminal justice oriented. It may be that the other state structures that are in place on this are generally geared to whether someone's going to harm somebody else, not themselves. And self-harm may be more the civil commitment context. But I'll take a look at some of those statutes. I haven't focused on that particular piece of it and see if there's been any. First of all, I'm curious whether the other statutes are specifically about harm to somebody else rather than self. And then secondly, whether or not Senator Bahowski's point has ever been raised and decided by court.
Yeah, if I briefly might just touch on, I agree with what Senator Bruce says as far as 98% is always a risk. But let me point out once again, there's a large difference between 51% and 99%. Therein lies my concern.
Yep. Yeah.
So I guess on this piece, I mean, I'm still leaning more towards a preponderance, but developing potentially a list of factors that shall be taken into consideration by the court prior to releasing somebody. And I think that could be a question for, could be another question that I asked Judge Zone and we'll CC the committee. Could also be a question for EMH on Thursday when they come in. I think we should move on, because we're running short on time here, to the next, the remaining parts of this section. Are there any other thoughts?
This goes back to something Senator Bahowski was raising, and I'm on page 6. The Commissioner of Corrections shall provide adequate care and individualized treatment at the forensic facility. Are we settled on who's running?
No, I think that's one of the bigger questions that we haven't reached a conclusion on, which I think maybe we will be able to reach a conclusion on after our testimony on Thursday.
Okay.
I haven't given that additional thought since our last conversation. Did you have your hand up?
To make the exact same point Senator Bruce did. I also wonder, and has the ACLU been in to testify on this, given that they're the sort of civil liberties protectors?
No, they haven't.
Okay.
Any other pieces or recommendations or changes in section 3?
Well, now I'm sure we'll work our way through this process.
Well, we've got the same issue about shifting the burden and evidence standard on page 6.
And then when we get into section 4, it's the same question of who and where.
One thing that I did have noted on mine was on page 8, line 6. The timeline for bringing in a petition. So I think that, I would prefer having something shorter than a year, but then we have the accompanying language of unless a shorter duration is authorized by the court. So I'm wondering if that's something where an attorney would file a motion stating that there's been a material change in circumstances, similar to how they would spell that out in a motion to modify conditions of release. And if that is true, that in their motion they could raise that there are material change in circumstances, and so it's warranted to have a hearing sooner than in 1 year, then I'm fine with the way it's written. But Eric, do you happen to know, or because this is all new, it's uncertain?
I agree with you, or I would read it that way, that second clause, unless a shorter duration is authorized by the court, would, like for example, my defense counsel, I would certainly argue that that provided the court some discretion, perhaps because, as you say, the person has taken significant steps toward regaining, treating their mental illness, toward being less dangerous, whatever those change in circumstances might be. And yeah, I would at least think that there's an avenue there for filing a motion. But again, that's, I think there's an avenue. It's not entirely clear whether the court would grant or not. So if you wanted to have a shorter period, that's certainly a policy call that is up to the committee.
Would it be worthwhile or unnecessary to add an additional point saying that the court may grant the petition and schedule a hearing if there is a material change in circumstances for the defendant? Would that make it more clear?
Yeah, I think that would have some clarity. Yeah.
Any opposition to adding that?
You mean replacing shorter duration authorized by the court with that?
No, adding on top of it, that shorter duration is
Authorized because there's been a material.
is authorized if authorized by the court, or if there is a material change in circumstances.
Or you could even add another sentence, because in a way you're kind of giving an example of or giving a way in which, like, there might be other reasons that the court would authorize a shorter period of time. Now you're kind of providing an example. You say the court, period after court, and then say the court may grant the petition. As you were saying, Senator Sheen, if it finds that there's been a material change in circumstances, you could even say that may warrant release or something like that, because the whole thing that's about a petition for release, so something like that. Sort of giving one example of a way in which a petition for a shorter time period could be authorized, but at the same time not tying the court's hands to say that that's the only reason that they might authorize a shorter time period.
Yeah, I'm fine with that for now. I think that should work. Do you have your hand up?
No, I don't oppose that whatsoever.
Great. All right, so I think we can pause there as we get to section 4, and that's just going into the definition of forensic facility. And that's that for now. Would we be able to get the new version for tomorrow before we get all these witnesses in?
Yeah, I mean, there's not a significant amount of redrafting at this point, so yeah, I can certainly be done for.
Yeah, I mean, if there isn't anything too substantial, then we don't. Maybe it's not necessary. But, I mean, as long as they've got these changes and we have our questions for them, then I think tomorrow will be enlightening. I think one of the big questions that we have to resolve is whether or not it'll be permissible to have this forensic facility be physically part of a correctional facility, or if we're going to try using the Berlin Psychiatric Hospital or Brattleboro Retreat or wherever. Yeah, okay.
Yeah.
Thank you.
So hold off on a new draft now. Okay.
Yeah, I think you can hold off for now.
Okay.
Yeah, you can hold off for now.
Okay.
Thank you.
You bet.
All right. So we can switch gears to S-183. Thank you.
183, I think I already have it.
I got it.
Great.
No. What draft?
2.1 of S183.
2.1, 11:10 a.m.
No, I got one more. Thank you.
Morning.
Good morning. Wait, could we just, we were just getting started, but I just heard just
yeah.
this morning from Erica
Turn it up.
March that
Oh, wait.
she would come in and support us with change. I suggested moving this all to the 80s.
Okay. Like 5 or 10 minutes?
I don't think so. Like I said, I just got an email from Kim McManus
It's, Emery can have that one. I found it. Thanks.
at
Thanks.
9:15 this morning saying that Erica could be available. I don't know that she's gonna be available in 5 minutes, but I can certainly ask.
Okay, yeah, if you could ask, that would be good.
Okay.
I mean, I know we had testimony on it 2 weeks ago, but I think Todd is on his way as well.
I've also reached out to the governor's office as their supportive, but I haven't heard back from them. So I've been trying to kind of get the people, but it's slow sometimes.
Hi.
Good morning.
Morning. So we're here on S183 for a discussion and possible vote. Were there any changes made since we last, or could you remind us, please?
So I'll just tell you, so for the record, Michelle Childs, Office of Legislative Counsel, and you should have draft 2.1 committee amendment. When I was here last week, there was a change that the Attorney General's office had suggested on including a change order when you're entering into the contract or if you are entering into a change order. And they had just sent it, changing it one place, and then as we were walking through, I realized it needed to be kind of brought through the whole section, so I just did a redraft of that. So substantively, it's not any different than what you were talking about at the last hearing. And so what you have here is, it's an individual instance of amendment, so it's just one amendment striking subsection B in your bill as introduced. Didn't need to, the other pieces that were in the bill as introduced, there were kind of just some technical stylized changes that we made, you know, when we're updating to gender neutral language or certain drafting conventions. And so this is just, in this amendment, it's just contains kind of the heart of the issue, which is subsection B. And it has the two issues that you've been discussing. One is the addition of the knowingly at the time the person enters into the contract agreement, and then now you've added the change order throughout there. So that's all it is.
Great.
Just a quick question, Michelle. On line 9, where you say, enters into contract agreement, is that like a verbal agreement we're talking about here?
You know, I'd have, probably, because if you see like written or oral, I was originally included that's different. I have to take a look.
I don't know why anybody would, but just in case,
Yeah.
Well, state statute is if it's over 10,000, you need to have it be written for residential contractors.
But anything less, you still have an entry into a contract, but you have to get 10,000 homes.
Written, yeah, over 10.
Right, you have the registry
Yeah.
with, you have two registries. One is with the Secretary of State's office. So if you engage in $10,000 kind of cumulative of business, you have to just register. It's not like a competency assessment or anything. You just have to register.
But you have to have it if it's over 10,000
Yes.
written
Yep.
contract. So if this is $1,000 or more, I'd imagine you could be oral still.
Right, and you'll see the language right there on line 9 where it says written or oral. So.
Okay. Any questions for Ledge Counsel on this? Okay. And Senator Verhofsky has a proposal regarding the AG, the SA. Do you want to?
Just the idea.
Yeah, what-
The language exists in a bill that's on our wall, which is S94, but I did not want to ask the Ledge Council to draft an amendment until I actually heard from the state's attorneys that they were going to come in and support this, which I got from them this morning. And that is taking the 80 or so cases of contractor fraud and moving them from the state's attorneys into the attorney general's jurisdiction. Currently, it's kind of shared. There's some civil, some criminal. The state's attorneys, and I don't want to speak for them, are sort of the opinion that could streamline these cases. But again, Erica Marthage, I heard from Kim McManus this morning that Erica Marthage, who is the head of the executive committee, could come in and testify, but I don't know if she can come in and testify this morning. But that is the proposal.
Have you reached out to the AGs?
The AG is sitting behind you, and we have talked about it, and they don't support it. This is sort of, I think it's important to hear from both sides of this conversation about why and what makes sense. And so I spent time last week trying to track down the players. Like I said, just unfortunately at 9:15 this morning, got an email saying, yes, the state's attorneys can come in.
So would Erica's testimony be different than what Kim testified to a couple of weeks ago when we first talked about this concept?
I believe it may be a little bit more in depth and kind of like on the ground what is the state's attorneys are experiencing. But again, I have had the information that she was ready to testify for less than an hour.
Yeah.
So I'm uncomfortable predicting what she would say, but my understanding is that she is practicing and the head of the executive committee, that she might just have a little bit more sort of logistical, experiential explanation as to why they think this is a good idea.
So, I mean, on one hand, if, you know, what we've heard already is that the state's attorneys support it and the AG doesn't support it, and that we wouldn't really gain, I mean, maybe we will gain new information by hearing from Erica, but, you know, I'm not sure. Well, actually, let me ask the committee, what are folks' general thoughts on further pursuing this idea and adding it to this bill?
Making the switch from state's attorney to AGs?
Not necessarily, but having additional conversations about it.
And currently it's shared jurisdiction, so it would just be.
And I forget, what's the rationale? Just workload?
Workload, speed, the speed at which these cases, you know, in this, with the sort of overloaded workload, you know, our state's attorneys have on average about 400 cases per. These tend to not be prioritized over, you know, assaults, and so that, and that may be some of what Erica can offer. The governor is also supportive of the larger scope of S94, so I've also reached out to his office to see if they want to come speak to this small piece of it. So S94 is taking a whole bunch of stuff out of the essays and putting it into, of which this was one of the things.
Gotcha.
And so I haven't heard back from the governor's office, so I don't want to put them on.
I feel like it would be maybe more important to hear from the AG's office, because their workload would be increased by this. I think you can usually get a party in government to say, we'll spin off our workload to other people. So would it be appropriate to hear from the AG's office at this point?
Yeah, no, it definitely would. I'm just trying to gain a sense as to whether or not the committee wants to go further explore this topic. We had it just slated for a vote, but this is a whole other policy change that would accompany this bill. Sarah Norris, this is your bill after all. What are your?
This is the bill that I propose, yes. Listen, I just want to see justice for these alleged victims out there. I can understand why the state's attorneys may be interested in getting rid of this, and I can understand why the AG's office may not be interested in taking them. I don't want to get this going back and forth between the two state agencies, obviously. I just want a simple, clean-cut way for victims of alleged crimes where they can actually get some satisfaction. I'm not sure if it's true. Both officers are capable of My concern is, what I'm worried about is a time frame. As far as filing, as far as, I mean, we talk about speed trials, this pertains to the same thing here. One of the alleged victims will be looking for some compensation or whatever else here. How long they're gonna have to wait depending on which office has it. They're both capable. I just want the quickest route possible, whether it's the AG's office or state attorney's office, and that's my take on this. I don't have a problem as it exists right now. But I don't oppose what, the senator is proposing here, but I just want to make sure that the wheels of justice move quickly on this.
Well, the sense I'm getting then is that it, I guess, seems somewhat neutral towards further exploring this policy idea. So if Erica has new information that she can share, then it can't hurt to hear further. So with that in mind, I think we should hear from Todd, who's here now, and then we can find a time for Erica, 20 or 30 minutes next week, and then conclude this one way or the other. So Todd, do you want to testify?
I'm happy to provide it, or if you're bringing State Attorney Martha in, we can both.
Yeah, I think we're going to try finding a time next week. And yes, please.
For the record, Todd Delos, Assistant Attorney General. Good morning. So we continue in opposition of this change, and I think Senator Norris, you sort of flagged it just now. What this proposed change would do would be to move these 90 or so cases from 105 attorneys. So roughly all the state's attorneys plus the 5 criminal attorneys we've got at the AGO to just the 5. That's really all it does, right? We already have jurisdiction concurrent with the state's attorneys to prosecute these cases. In the past, we've done it when we had different capacity. We haven't had that capacity. I can go into that a little bit more for the last couple of years. But at the end of the day, you'd be taking discretion away from the local prosecutors and handing it to the 5 folks who sit at the AGO who are currently working on mostly aggravated felonies and the internet crimes against children cases. The other issue you'd have, which is one of the tensions here, and I think the tension that the bill that Senator Mahowski has on the wall, we don't have direct connection with a lot of law enforcement, right? So ICAC has an investigative body. They work directly with us. Otherwise, with only some specific exceptions, we don't get phone calls from the state police. We don't get phone calls from local law enforcement. All the cases filter through the state's attorney's office. And so I think there are other challenges with sort of taking some of these either more challenging cases or less prioritized cases and just handing them, essentially carving out the state's attorney's jurisdiction. The only place that exists in law is homicide. That's the only area that the AG has exclusive jurisdiction, and she regularly ensures that the local prosecutor has the first opportunity to prosecute the crimes in their local community, especially the most egregious crimes. We offer to support all state's attorneys around any new homicides. Sometimes they take us up on it, sometimes they don't, but that's the collaborative relationship. We can continue in that collaborative relationship. This change, essentially, as I said at the outset, would move from a pool of 100 plus attorneys to a pool of 5 attorneys.
Just a couple of questions. How many of these types of cases does your office have right now?
No.
None. And
Sorry, none in the criminal context. We do some of this work in the civil context where it's a consumer fraud claim. And I know one of the arguments has been, well, you've got this consumer expertise, wouldn't that help in the criminal case? The reality is it's the criminal division who does the criminal work and the consumer division that does the consumer work. That consumer division is available to state's attorneys as well. It's not, we're all working on behalf of the state. So it's not as though the proximity within a building is really the limiting factor.
And there was another point you'd raised regarding prosecuting crimes in the community. Obviously, each state's attorney has their office in a county, but as far as I know, the AG's office is situated in Montpelier, and Burlington?
Principally just here, the criminal division is just here in Montpelier. Then
ICAC is in Burlington.
there are elements of ICAC,
Yeah.
and then we also have, embedded AAGs and AHS and other places, but those are not germane to this conversation.
So would it be an issue if assistant AGs are getting these cases in Bennington or Orleans County and they have no connection to, they have no rapport or connection with the police department that initiated the case or the community itself? Would that be?
I think I think that's absolutely a challenge, developing those relationships, and then also just the logistics of going to court halfway across or 3/4 of the way across the state for these largely misdemeanor cases.
Thank you. Senator Lewis?
I just touched on it. My question is going to be, so if in fact it did shift to the AG's office, would that make the alleged victims go to Montpelier, or would the AG's office have to go to the individual county or what? And you said you'd be traveling to the Benningtons and the Franklin County.
Yeah, I mean, I think local law enforcement would be doing the investigative side of it, but then working with victims would very likely, I mean, of course, it's post-COVID, we've got all the technology to do it virtually, but yeah, when you meet with victims, you want to make sure you're face to face, and it would be a lot of travel. And I'll also just say, the reality is, again, as you move from a pool of all the criminal prosecuting attorneys down to just 5 of them, cases are not going to move faster.
Senator Bills?
What is the average caseload of the attorneys in the criminal division?
I don't have the exact number. It is far less than the average caseload for the state's attorneys. But I will say there's a significant difference between prosecuting a DUI and prosecuting a homicide with mental health components.
No, absolutely. Would not argue that. Yeah, that's it.
Any other questions for Todd? Okay. Well, thank you. We'll hear from Erica at some point next week and then decide what to do on this and move forward. Yeah, thanks for coming in.
Happy to come back.
Appreciate it.
Yeah, thank you.
All right, next up we have Senator Lyons on Prop 4. Switching gears here.
Good morning.
Welcome.
Well, thank you. Thanks for having me. For the record, Senator Ginny Lyons, and I'm here to talk about Prop 4. And I know that I've been in to talk about it before, but I'm coming in just first to say thank you for the work that you continue to do on this. And secondly, to offer some comments, because I think it's important that we continue to emphasize the significance of this Inclusive Equal Rights Amendment. And as you know, I started working on this in 2016, and then in 2017, we passed a resolution, which I brought with me, and then we introduced the constitutional amendment in 2022, and it didn't go at that time. There were other things going on, and now here we are in the second biennium, ready to pass the constitutional amendment. And so my thanks go to you for that. And I will be a little bit repetitious in what you know about Prop 4, but I did want to share my thoughts very briefly. That we know that Chapter 1, Article 1 of the Constitution states that all persons are born equally free and independent and have certain unalienable rights. That is in the proposed amendment that you have. Chapter 1, Article 7 states that government is or ought to be instituted for the common benefit, protection, and security of the people, or Common Benefits Clause. You know, when I started thinking about this, I was going to introduce a constitutional amendment for equal rights for women. And I realized very soon that there are other groups that should be included. So an inclusive equal rights amendment in our Constitution will affirm what currently exists in our society. Our Constitution does not begin, and this is a quote, or it's not a quote, it's, what do you call it? I'm taking from Gloria Steinem, believe it or not. Our Constitution does not begin with I, the president, or I, the governor. Our Constitution begins with we, the people. People working for a democracy in which we are linked as human beings, not ranked by race, gender, class, or any other label. And I credit Gloria Steinem with that concept, but it's something I think we all think about. Inclusion is something Vermont's laws continue to express. Vermont values are based in racial, social, economic justice, and the freedom of self-determination. Historic data demonstrate that specific groups have been discriminated against based on biologic determinants, resulting in social, economic, cultural, legal prejudice and bias. These include gender-based groups, gender identity, include religion, ethnicity, and racial heritage or disabilities. Holding people hostage as a result of their biology or religious beliefs is antithetical to Vermont values. We have passed laws to protect these groups, but laws can be changed. So it requires that we don't want to lead to inequality, but rather to increase legal or ethical dilemmas. An inclusive ERA provides a constitutional umbrella to protect all of us, regardless of who we are, and build equal protection under the law. 24 other states already have a constitutional amendment comparable to the one that you have worked on. And one of the things I was listening to today was recognition of Black History Month. And the conversation went to, well, currently at the federal level, there's an interest in homogenizing and not recognizing different groups. But I think we know that a recognition of differences advances us socially and culturally and legally. We don't want to homogenize, rather we want to harmonize through democracy and cultural understanding. And I think that this constitutional amendment is a step forward in doing that. And it does represent who we are and who we have been in Vermont. So that's all I wanted to say. Thank you for having me.
Thank you for coming in, and thank you for starting this process a number of years ago. It's appreciated. Committee, any questions for Senator Lyon? Okay. Great. Well, thank you for your time.
Thank you. Now I can go back. And I have an intern with me today, Sophie from South Burlington.
Nice.
Okay, I'll see you guys later.
Thank you.
Just one second. Is that okay?
Any further discussion on Prop 4?
No, I'm excited to see it maybe is up for a vote today.
Any questions, any additional witnesses that folks want to hear from? Anybody?
I would just note that we can't change it.
Right.
So,
Yes.
for anybody watching.
Want to make sure that everybody feels like they can hear from whomever they need to hear from. No questions to Ledge Council? And no witnesses, no further discussion? Okay. Then I would entertain a motion to vote Prop 4 out favorably.
So moved.
You need a second.
I'll second that.
Great. Any further discussion? Okay, if you could call the roll, Senator Maddox?
Senator Norris.
Yes.
Senator Baruch.
Yes.
Senator Matos, yes. Senator Vihovsky.
Yes.
Senator Hashim.
Yes.
5-0-0.
And I am happy to report this out on the floor. I reported it out the first time around, which was an experience. So happy to take it the second time as well.
And we are happy that you are happy to report it out on the floor.
I'm happy that you're happy.
I'm happy that everybody is happy.
Let's just bathe in that for a brief moment.
It may be brief.
Indubitably.
So Eric, thank you.
Yeah, sure. I'm happy to.
Okay.
We're full of happy people.
All right,
That's blown over.
so we next have 151 at 11. Is there anything that
It's great.
we need to discuss before 11, or folks want a lengthy break?
I'll vote for, I'll make a motion for a lengthy break.
I always support Bob.
Okay. So moved. All right.